take a look at the latest appointment of Queen's Counsel Qureshi. Now, confusion greeted the Office of the Director of Public Prosecutions. This after senior lawyers representing Kenya's Deputy Chief Justice Philomena Mwilu banded together to stop his participation in the corruption case. Tough opposition welcomed Queen's Counsel Qureshi on his first day of duty in Thursday, as defense lawyers led by Siaya Senator Senior Counsel James Orengo accused the state of acting contrary to the law in appointing him. And as KTN's Francis Ontomwa now reports, the proceedings now leave the foreign lawyer's fate up in the air.
Right from the moment the court set out for the day's business, it was more than apparent that a real showdown was in the offing. A 5-judge bench took its position, but one man will steal the thunder from everything else. Qureshi, Queen's Counsel, a professor of law that came loaded with the DPP's bags of potential.
Yes.
But it did not take long before the defense pulled a hard tackle on the British professor. The manner on how Qureshi was gazetted to take up his new role became a subject of discussion, and all the time this went on, Qureshi appeared utterly bewildered.
The Director of Public Prosecution is exercising powers that he does not have, and that is to appoint our land friend, the good professor, to act in this proceeding.
Also senators who sit on the...
And in what appeared to be an opposite reaction to the pressure, veteran state prosecutor Dorcas Oduor shot up with another shocker. Oduor and team want Senators James Orengo and Okongo Omogeni also locked out of the proceedings on conflict of interest.
Where do we draw the line about the information they come by as senators and MPs and how they use it against their clients who pay them money? That line must be drawn.
The DPP Nordin Haji is on record that the single sourcing of Qureshi was arrived at after his office failed to receive applications from Kenya's senior lawyers who will exhibit independence in the matter.
Matter proceeds.
Insiders have told KTN News that the appointment of Qureshi may have acted the league of senior lawyers in the country who felt demeaned by the move. Qureshi, a lawyer of more than 30 years' experience, however, appears unmoved.
My understanding is that the very reason why he instructed me was despite the lack of any substance to those assertions, he is doing everything he can to demonstrate he is acting independently and fairly, and by appointing an independent Queen's Counsel from England, that should hopefully satisfy. But the objection, the blocking that's been taken to me, no doubt the court will determine this on the 17th of January.
The judges have directed the matter will be next handled on the 17th January 2019. Despite massive bidding for the UK-based professor by the DPP's office, it now appears that some senior lawyers are questioning his presence in the case and want him out bag and baggage, something that now may push the prosecution back to the drawing board. Francis Ontomwa, KTN News, Milimani Law Courts, Nairobi.
Well, interesting developments in that particular topic ever since the office of the DPP, through single sourcing after advertising for private legal counsel and being unable to find suitable candidates due to the unique nature of this particular case and the requirements and complexity as well. Now, we've seen the Queen's Counsel make his first appearance in the courts, and it was based, that particular hearing was based on amicus curiae, who to enjoin in this particular case. But the objective turned quickly as they listened to introductions from all parties, raising the fitness of Queen's Counsel Qureshi. Perhaps let's start with you. Being a lawyer, how is the process in terms of actually bringing on board a partner from the Commonwealth countries to actually represent and mitigate a case as a prosecutor?
Jesse, what is happening here is just a small compliance issue that has been overlooked at.
Okay.
It has an issue going forward because if it is not addressed at this point, in the future somebody might come back and ask the court to declare the whole proceedings a nullity because of what happened. What is supposed to have been done initially is that the DPP is supposed to write to the AG requesting that they want to bring on board somebody from the Commonwealth, person ABCD, setting out their resume, so that it can be known in the letter in the request letter that this person has the following competences that cannot be found within the country, or that he can perform a special purpose. That is now to the AG, and after that, the AG will admit this person. But in the admission of the Attorney General alone, under Article 11 of the Cap 16 Advocates Act, is not enough for you, if you are admitted today, to wake up one day in the morning and go to court. You need to go to the registrar of the judiciary and pay a fee to get a certificate of admission. It is after this that you can now pay for your practicing certificate and be allowed in our court of law. It is a very simple process. It is just covered by 3 sections of our Advocates Act, 9, 10, and 11. And I don't see the reason why the DPP might have opted out of the process. Why bring in somebody from all the way to Britain to come here and embarrass a small process? But to my point as a lawyer is that I do not subscribe to the school of thought that there was a reason for Qureshi to be brought here. Whether there is that legal mandate or whoever is allowed to bring in a Queen's Counsel is a different thing. But for them to bring in somebody to try our internal matters is an admission from the part of the DPP that there is an ineptness from his own side. If he does not trust the Kenyan lawyers to prosecute those matters, why doesn't he wake up in the morning and go to court and prosecute them himself? And wisdom of the old has showed us that prosecutors, directors of public prosecutions worldwide are renowned trial advocates. You cannot learn prosecution on the job. You must have been somewhere, it is an art. Prosecution is an art. You don't learn overnight. And look at it this way, we are in the same situation with the South Africa. They appointed somebody who has had experience. We are where we are because of these problems, because of an issue in terms of experience. But Qureshi might not help this, because what we are going to do in court is about context. What we are going to do in court is about evidence. Any advocate can do that. The other thing, what we are doing to our profession is this. Tomorrow, NIC and CBA will be merging. What stops them from asking the AG that they need to bring somebody from Caymans or any other Commonwealth country to come here? What is happening to that? We are taking money out of this jurisdiction while we have competent people. A country that has produced an ICC judge should not be fishing for people to come and help us do our things. Down the line, what we will do in the process, next year or 2-3 years down the line, we will be saying, why don't we hire a Commonwealth Chief Justice to help us sort our issues? Our local problems need our local minds to solve them.
Well, very interesting.
Looking at it this way, experience is beating us down in the whole DPP issue. And I think, from where I sit, the DPP has laid his bed, and it is time he sleeps on it now.
Well, chicken have come home to roost. Hesbon Owila, well, he's mentioned on the perhaps the suitability of this particular individual brought from London all the way to Kenya to actually prosecute this particular high-level case that enshrines the DCJ Philomena Mwilu. But during something that stood out, even as you answer that, something that stood out in the story we've just listened is that they actually, the prosecution also poked holes in the eligibility of various individuals who are representing the DCJ, particularly Senior Counsel James Orengo, as well as the Nyamira Senator as well, who is also representing Okongo Omogeni, who is also representing the defense. Now, they also serve in the Senate, an oversight body, and they mentioned that it created a conflict. How do we approach it?
Well, just listening to lawyers, and Kichumba has also made this clear, that a ruling had already been made on that. I mean, I think this is something that had been raised before on whether the senator can represent, given the privileged information that he gets in Parliament. And it's already clear that there's no problem, there's no conflict of interest. You know? So it's taking us away from the crux of the matter, which is the suitability of bringing in somebody else to prosecute a case, and whether it is in our interest to set that kind of a precedence. I mean, the issue is not whether Orengo is having privileged information and therefore conflict of interest. The issue is how did we find ourselves in this place? And is it the right thing to do to bring, an accomplished professor? I've gone through his CV and I listened to him and the experience that he has. I mean, it's just out of this world. So that's the issue, that do we need all that? And I think Kipchumba has candidly said that there's a serious issue in terms of getting the right people to prosecute the Deputy Chief Justice because of the position that she occupies. So maybe lawyers are not comfortable, maybe even officers within the DPP's office are not comfortable, because again, this is the second in command in the judiciary. But then there is the independence of the office of the DPP, in which case, if he can't get somebody suitable, he's a bona fide prosecutor. I mean, he's probably the best that we have in the country, and that's why he was appointed there, and Parliament affirmed his appointment. And I think we saw the former DPP, Keriako Tobiko, appear in court and prosecute issues. So that is what we should focus on. That is it something that we have to do, get somebody from elsewhere? And what kind of precedence does it set? What does it communicate, to other Kenyans, people who have aspirations to ascend to the highest offices, to prosecute big cases? Are we going to set up precedents that will lead us to a situation where I've seen lawyers fight online, and use very unpalatable words against each other, some even questioning where some were born. So this thing is becoming a lot more complicated, yet the question is very simple. Did we even have to have the Deputy Chief Justice in a magistrate court of law? I doubt. Because the Constitution is very clear. This was supposed to be handled in a totally different way. So I think the DPP just put himself in trouble, and from where I see it, he's compounding that trouble by making things a lot more complicated for him.
Well, it is the renewed fight against graft, and this is the message that the Director of Public Prosecution, Nurdin Haji, actually came with in terms of fighting graft. We saw high-level arrests, and Kenyans perhaps question all this. We've had them bring in the fact that arrests are made on Friday, then Monday back to court, and they sleep. It's so much drama happening. Now let's look at the overall objective, the fight against graft, especially by top-level officials holding top-level seats in government and also in the judiciary, talking about Philomena Mwilu. Is this the message or the direction that we surely should head? Because we've had the DPP being put into question, criticized for his method of fighting corruption, if you can use those words. Is this the right direction, according to you, Bichachi?
The fight against corruption in this country was bound to get messy. It was bound to be bloody. It is literally a war. In fact, social media has been awash with lists that show that members of a certain community are the ones who have been targeted. And I've seen another list saying you forgot this other list. So we've made it tribal. Now we've made it about Commonwealth lawyers, and we will make it about anything to try and protect ourselves, our corrupt selves, from the consequences of justice. And the truth of the matter is, in this particular war against corruption, the end is what will justify the means. And one of the biggest issues that we have in this country, and the Acacia case has proven this, is we have a corrupt judiciary and we have a corrupt legal profession in this country. This is something that even the Grand Mullah himself tweeted the other day, saying that this country's lawyers are picked from a corrupt population, and from these corrupt lawyers we pick corrupt judges, and therefore the entire system is corrupt. And if it is not corrupt, then justice is delayed. A friend of mine was telling me that she's had a case for over 10 years and it was being resolved last year. So there is definitely issues that need to be dealt with. And if you're going to fight corruption, you've got to start with the chief and the policeman who collect bribes on the street. You go all the way to a CS who presides over corruption. And then the last bastion of corruption which we must deal with is the judiciary. And it is in that perspective that I think the DPP, rightfully so, decided to take someone from outside this country to handle a judicial matter, because I can only imagine imagine the powers that Philomena Mwilu has, both in office and in terms of influence, if I am a lawyer who's got 20 other cases to represent, and now I must put all these other 20 cases in jeopardy because Mwilu can give a call to a certain judge and just tell her, unajua nataka nini, and not say anything else. Perhaps that is the fear. So there is a need to insulate the prosecution of Justice Mwilu from the influence that she wields within this profession. These are her colleagues. It is like me, Hesbon, being a judge, and I'm being the one prosecuted. It will go very well for me. So there are very many things to consider, but the nuances and the kind of judiciary we have required that this particular case be insulated from undue influence.
Well, Dismas, so much has been said. I don't know where we will come in, but I think let's take a look at also the capacity of the DPP, the DCI. We can also include the EACC in terms of fighting graft. Earlier on, you mentioned, forget about the Big Four agenda. The fight against corruption should be the sole mandate of President Uhuru Kenyatta.
Absolutely, and so much has said, but nothing has been done on the war against corruption. Now, we're having Independence Day a few days from tomorrow, and it's a sad reality that as a nation, about 6 decades later, we still have to import human resource to come and assist us do cases. We are a member of the Commonwealth, yes, but now we have to go to the Queen, Her Majesty, and seek resources to come and do this. But that's now in theory. But why are we doing this? The DPP said he ran adverts and requested for Kenyan lawyers to declare their interest in being prosecutors. And he says when the lawyers saw this, they disappeared into a thick forest. They don't want to engage in these matters for some reason. And when you speak to insiders, the insiders claim there's a very high probability that you've got cartels or groups of lawyers who do not want to pursue this matter because they do not know the outcome. That this could be suicide for you as a lawyer. You know that your profession may come to an abrupt end. Now, if you're the DPP and you've got constitutional powers to get resources from the UK or from within the Commonwealth, what do? Do you call President Kenyatta and say, thanks a lot for giving me this job, I'm unable to deliver, I'm going back to the National Intelligence Service? You go through the powers given unto you by the people of Kenya, by Moraa from Mososho, and one of such is that you can get external help. So you go to the UK and you get help. What is the big deal? Why are Kenyan lawyers complaining? Yes, they were given the opportunity to declare their interest, and they did not. Why are they complaining? So this war, as Winston Churchill indicated, you're going to fight it in air, land, and water. The DPP has said, I'm going to use all the resources available to me to fight this thing. So if he's going to get a Queen's Counsel by the name Qureshi to Kenya, so be it. If he's going to get another 20 lawyers from Ghana, from Nigeria, from New Zealand, from Australia, if they are going to fight, they're going to assist us kill corruption, we should be giving him a pat on the back. And you know, Kenyans, we are very crazy lot. We expect results. The DPP goes the extra mile to look for a resource, and then we start saying the DPP has made his bed, he needs to lie on it, but he's given powers by the Constitution. Some of the MPs who are claiming that we are going to become a laughing stock, why can't they go and amend the Constitution and say that you can, if you're not a Kenyan lawyer, you cannot practice law in Kenya? Why are we complaining? I mean, every single day, you've seen the headline in the Standard. We need lawyers with capacity, with resources to go and fight. The DPP requests you to do this. No, relax. Calm down. Let me finish. The DPP requests for this kind of resource. The local lawyers are not interested. It goes to the UK. Then again, we are jumping all over, making noise. But now the sad issue is, there's a very high probability that what Qureshi has been requested to do is merely doing press-ups. That is being groomed to fry bigger fish. Because the Kenyan lawyers, for some reason, if you're going to be given an assignment, you ask yourself, on what political side of the equation am I? If I'm said to be NASA-aligning, I'm going to prosecute a NASA-aligning MP, would I go back home? What will my colleagues think of me in the evening? What will my villagers? And you see, that's the reason that the DPP now is being held hostage. He has to go and look for this resource.
Okay.
But for me, what I'm able to see from my crystal ball, in the next few days, we are going to be told that this corruption matters in Kenya are so serious, there are no Kenyan judges got capacity to do that. Now let's go get an Indian, let's go get a Chinese, provided in the Commonwealth, bring Kenya. We will not be surprised if the Judicial Service Commission runs adverts in The Economist or the Financial Times of London to request for people from within the Commonwealth to join our bench. And this is a sad reality for us. I mean, as a country, our leadership should be a global embarrassment. That 60 years after independence, you cannot trust local talent to do this. And also, our lawyers must ask themselves questions. After going through law school, you know, having these serious qualifications, why can't you stand out and go do this prosecution? If the older lawyers do not have the guts or energy, why can't Karoria take this opportunity and go and make out his brand the way other lawyers have done?
Karori, I think it's only, yes.
Just a question. One, we cannot allow this mass to use this platform to lie to the whole country of 45 million people. The DPP did run those adverts. He selected 3 advocates, Senior Philip Murgor, Senior Kihara. I can't recall the other name. But he selected the 3 and he got around, from what I could see in the press, around 300 applications. So, but what we must address is this, and I must tell the DPP from the onset, one, we do understand that he has never been a trial lawyer. He has never stepped in a criminal court. And people, and the mandate he was given, is he peruses a file, looks at the strength of the evidence, recommends. For people to continue trusting in that recommendation, it must be seen in court. Because we have ran a prosecution so far on PR, the PR must be sustained. And the other thing that I must remind him on a national TV is that credibility is like virginity. It is lost only once.
And that's it.
Just let me make a clarification. He's accused me of lying. The DPP said himself, and the producer can get the clips, that he was looking for specific talent, and he did not get the talent he was looking for. And the talent is available elsewhere. That's number one. Then number two, you must not be a successful trial lawyer for you to be a prosecutor. A leader is supposed to create systems. He's now creating systems. I mean, he's creating systems. You do not expect the DPP to be in all the courts in Kenya. He's creating infrastructure. Why are we complaining? I mean, why are we afraid?
Okay, let's give this to gentlemen 1 minute each. Let's dissect what they've said, as well as the role of the judiciary.
It's very important to remind Kipchumba that professionals built the Titanic and an amateur built the Ark. We know what happened in those stories. Just because he's not been a trial lawyer, probably that's the reason he's able to do what he's doing, because he's never been corrupt. That's number one. I'm saying the reason why he's probably able to do his job is because he's not been tainted by the system. Number two, let's remember that there is one qualification that is in short supply in this country. It's called integrity. That's the biggest issue. Kenyans are the smartest people. You take a Kenyan to the UK, they sort out UK traffic. You take them to The Hague, they become the ICC judges. You bring them to Kenya, they cause matatus to get out of town. The other thing is, let's be very clear, that the Akashas were innocent in Nairobi, innocent in Mombasa. In New York, they were guilty. Chicken Gate was innocent in Kenya. In the UK, they were guilty. What magic happens?
Interesting.
So about these trial lawyers.
30 seconds, briefly.
I think Dismas and Mark are raising hopes of Kenyans. You know, Dismas has talked about this guy is coming for big fish. Yet the mandate is very clear that this guy is only going to sort one case. You know,
but it could be even addition.
Let me tell you. Let me just finish. Whether he will succeed, whether he'll succeed or not is another problem. Now, the issue is when we raise expectations and we bring in a high-profile professor to come and prosecute a case, and then it collapses. Essentially, what we are communicating is the fact that there is runaway corruption, and it is a good thing, because that is what we are going to celebrate. That we raise expectations, we don't sort, we see people who are prosecuted get out and they're not guilty. We will want to believe that corruption is a good thing. And that's the danger that
allow us.
The issue of revisiting also has some implication here. We have seen people stealing money left, right, and center. no QC has been brought in.
Exactly.
But when it comes to the judiciary, does it mean that there is a subtle fight somewhere of people fighting the judiciary to the extent that we are bringing in Queen's Counsel and we are not bringing in Queen's Counsel to work on the corrupt people?
Kipchumba Karuri, I'm sure this particular topic touches a very sensitive point, but let's take a short break right now. A lot to talk about on that particular issue, but we'll have to leave it at that. One thing that stands out, the integrity question is very fundamental, and that's what we'll be talking about after this short break. We'll take a look at the man in question, former Vice President Moody Award.